Yes, Mr. Brown.
My Lord, still on my second heading,
Yeah.
I made my submissions on what I say is the clear and natural meaning of the words of Schedule 11. And of course, the point taken against me is that SEW contend that Schedule 11 only applies if SEW elects to seek an actual replacement. So as I understand the submission, SEW can choose whether it applies or not. It's an additional warranty in their submission, but it doesn't restrict their rights. So their case is that if instead of seeking an actual replacement device, they sue for the damages or the costs of a replacement or exchange, then Schedule 11 does not apply. I do submit that they are occupying rather a narrow corner of the playing field by this stage, because as I understand Mr. Darton's case, if his clients seek a replacement, then the consequences are as set out in Schedule 11. There are limitations. But he can get around it just by simply not electing to go down that route and suing for damages. So the question for the court is that a commercially realistic proposition? Would the parties have intended, and I'm going to deal with the detail, but as a general point, would the parties have intended that
the question for the court is whether that's what the contract says. Aren't we warned these days by the very case you cited not to put too much weight on commercial sensibility?
Certainly, and your lordship has my submissions on the clear words of the contract. But I'm submitting here that, and I'll come to it, that the words of the contract don't support the additional warranty thesis. But in any event, there is the background point that it seems highly unlikely that parties would have drawn such a dividing line. Schedule 11 expressly limits the costs of replacements to the remedies set out in the warranty in the table. If SEW can seek the costs of replacement without reference to Schedule 11, then in my submission the costs of replacement are not being limited to the remedies in the warranty, as Schedule 11 states they must be. I note that the limitation is unqualified, shall be limited to. And I do submit why, or I do ask, why should the general words of limitation, shall be limited to, be given a very specific and qualified meaning proposed by SEW? My learned friend says that it is our side of the court that's inserting words, and it is not. SEW's case is that one takes Schedule 11, and let's just take it up so that we have the precise words. It's tab 9, page 113. And rather than the operative scope being should a faulty device be identified in operation, the cost of an equivalent shall be limited, one inserts the words, should a faulty device be identified in operation, and if Elster seeks a replacement under 13.13 of the Framework Agreement, the costs shall be limited to. That is my learned friend's case, as I understand it.
Well, I think his case is the cost to SE Water is of an equivalent is limited by the warranty, and the warranty is we'll provide it to you free of charge in some cases, but at a discounted price on other occasions, and that's the limitation of cost. It's the cost otherwise that South East Water would be paying for a replacement to Elster.
Yes, but I may be misunderstanding the question, but his pleaded case is concerned with those costs. He's seeking the costs of replacement, of going to find them.
Well, no. By definition, if it means, as South East Water say it means, it's the cost of replacement by Elster, because it can't mean anything else. Only Elster can be supplying free of charge or at a discounted rate. No one else can be forced to do that. So it's only applying, by definition, when Elster is supplying the replacement.
Yes, but it's premised, his case, on the idea that it only works if clause 13.13 is exercised.
Yes.
Yes. And so it may be that we really aren't far apart in this discussion, in that my case is that one does have to rewrite or insert words into those opening words of Schedule 11, because there is no such limitation, there is no such qualification to the words. Where does it say that the limitations on Elster's costs shall be limited only in the case where Elster seeks a replacement? It says it nowhere. Instead, it limits my client's liability in all cases where a faulty device is identified in operation. And I do submit that the problems become more difficult for SEW when one works through the examples. And Lord Justice Coulson noted example 2, which is an example that we rely on heavily. And we do say that it illustrates the error in SEW's position in a stark way. As Lord Justice Coulson notes, this is an example which deals with an AMR device failing to transmit in year 8 due to a premature battery failure. And that is the very issue, I submit, in this case. Now, it's a little unclear what SEW's case is when one deals with an AMR module which has failed for this reason in year 8. They do say that they should have lasted for 10 years. And no doubt Mr. Davies can clarify, but it appears to follow that it is SEW's case that if the AMR module failed in year 8, it could seek damages for the cost of replacing that AMR module from a third party. So you could go out to the market and just buy a replacement. And then you will be able to sue Elster on SEW's case for the full cost. Now that certainly appeared to be their case at first instance. For your Lordship's note at the para 119 of the judgment, core bundle paragraph 67, but there's no need to turn it up. But if that is so, then example 2 is entirely superfluous. Because example 2 is premised on a failure in year 8, and it will be SEW who pays Elster, admittedly a discounted price, but the money will be coming from SEW. Whereas the pleaded case, as I understand it, is that SEW is entitled to damages for the full value of this AMR module in year 8 from my client. So rather than it being them who pays for a year 8 module, it's my client that pays for the full value. Now, why on earth would you go out and ever pay for a discounted module if you had a right under the contract to sue for damages for the full cost? I do submit that example 2 makes no sense at all on SEW's case. It provides less than they say they're otherwise entitled to under the general provisions of the framework agreement. It therefore can't possibly be read as an optional provision. You would just, on SEW's case, always ignore in year 8 example 2 and sue for the full cost. And it comes later in the analysis on specific and general, but what we do have here quite clearly, and it is looking at the words rather than just commercial common sense, is that the parties have specifically addressed their mind to the particular failure that has occurred in this case, a battery failure in year 8. And they've addressed it, and they've said, as commercial parties, that what happens there is that it will be SEW that pays for a replacement. It won't be Elster that offers a free of charge replacement. It will be SEW that's got to pay in that instance to get a new one. But to compensate for the fact that you haven't had the full length of time of the product, we won't charge you the full value. The parties have expressly contemplated that situation. And in those circumstances, it cannot be the case, on the wording of the contract, that you could rip up that scheme and simply sue for the full price. That cannot be right. Now, what I imagine will be said, and this is why it's important in my submission, obviously in all cases it's important, but here to define the scope of the appeal, is that I think Mr. Darton will say, well, when you get into year 8, you get into diminution of value territory. So he appreciates that there'll be an element of betterment if you get a replacement, a full replacement in year 8. And I think his submission is that example 2 is in effect the parties agreeing what that loss in value was. They appreciated that there hadn't been the full value, and therefore you would give a discount on the replacement. But there are 2 points. One is there's no plea of diminution in value. It's a cost of replacement case. And the second point is that demonstrates in terms that the parties had in mind how to deal with the difficult issue of AMR modules which are installed and then fail over the course of their operation. And just from the clear words, the parties have sat down, or Elster has, and has proposed this scheme, and that's been agreed. And it leads to, in my submission, a simple and straightforward and commercial result. And I appreciate Lord Justice Males's question, which is that before the short adjournment, that what happens if you have a fallout and you don't trust the supplier? Do you go in an endless cycle of free of charge replacements? And my answer to that was there would come a stage. Obviously, the obligation would be to provide a free of charge replacement that works, and if not, you can then sue for damages under Schedule 11. But one has to really contemplate what the parties would have thought of at the time by reference to the words, and they were not envisaging those scenarios. They were envisaging a very straightforward commercial approach. If I have an AMR module which is faulty, what does SEW need? It needs a replacement so it can read meters. And this provides for that.
So are you saying that, take the Year 8 example?
Yes.
The only remedy open to South East Water is to operate the warranty in Schedule 8. It can't sue for damages based on diminution in value, and it can't operate the right under 13.2 to go into the market and buy a replacement. Are you saying it can't do those things?
It cannot run its pleaded case.
No, that's just...
And then on the diminution in value, that is an interesting question to which my answer is twofold. My primary case is that the parties have agreed that this is the only remedy, so you can't sue for diminution in value.
Right.
My secondary case is that if you can sue for diminution in value, then the agreed diminution in value is as set out in the discounted replacement formula.
And what about the right in 13.2? Which is to go and get a replacement in the market.
I will turn up the wording of that, my lord. 13.2, yes, my lord. 13.2 is entitled to recover any additional cost incurred by the purchaser in sourcing similar. I submit that's not the cost in sourcing, that's the additional cost of being inconvenienced by having to go out.
Right.
That's how I read that clause. If the products are not supplied in the purchaser, for the avoidance of doubt, you can sue for the additional costs incurred by the purchaser in sourcing similar products. It's not the cost of sourcing products from
is there no entitlement to recover the cost of sourcing alternative products under the contract?
Well, the costs of replacements are limited in accordance with Schedule 11, and I do submit there's nothing odd about that because of the reason I suggested, namely that you need a replacement for it, and you're being offered the free of charge replacement for a period of a number of years, and indeed discounted replacements going up to 15. So SEW had the comfort that for 15 years they'd be able to go back to us and essentially keep these AMR modules operating. Sorry, Lord.
You say that 13.2 is limited to additional costs, but wouldn't the ordinary cost of obtaining a replacement be covered by 13.1.6?
13.1.6 is the damages provision. Yes, there is a general... The starting position, of course, is just as I said in relation to 9.4, and I appreciate it's not a sale of goods act point, but it applies equally, the logic. If you have a general clause which allows you to claim damages, it can be limited by a provision elsewhere in the contract. Ordinarily, one would be able to recover lost profits or lost revenue within the scope of 13.16. By 9.4, you can't. Similarly, ordinarily, as your lordship points out, you'd be able to claim the costs of going out into the market and replacing these. But that is a extensive liability on the part of SEW. And we can see how it's worked in this case, my lords. and without getting too much into the facts, we
So
know...
13.1.6 gives you the right to go out into the market, and Schedule 11 takes it away.
No, it doesn't, my lord. That's not how I characterise
No?
it. One has to read them together consistently. There is no right to go out into the market to get a cost of replacement and hold my clients liable for it. Because one reads... It would be like... it depends how one views it. Your lordship may view 13.16 as giving you a right to loss of profits, which is then taken away from you by 9.4. I don't, in my submission, think that that's correct. It gets you to the same result. One reads the contract as a whole, and you don't have a right to loss of revenue or anticipated.
That's what I was trying to get at with the question. So it may not be 13.2, it may be 13.1.6 combined with 13.2, but there is a right under the contract to go into the market, get a replacement, and charge that to, claim that as damages from Elster, subject to Schedule 11. Schedule 11 is where you say that right's taken away, do you?
No, my lord, I say I don't accept that there's a right to sue my client for damages or replacement.
And why not?
Because of the Schedule 11. I should be more specific than that. Where there's a faulty device identified in operation, there is no right to go out into the market. Of course, there's a right. They can go and do what they like, but they can't sue my clients for damages for the full cost of those replacements.
Well, for the full cost, you say. Are you saying it takes away the right at all, or it puts a limitation on the amount they can claim?
It's a limitation on the
Right.
on the amount.
And what is so taking the example in example 2 in year 8, what is the limitation on the amount they can claim from you?
They would have to pay us. In year 8, they're not entitled to any sums from us. They're entitled to exercise a right to obtain a replacement at a discounted price.
So that does take away their right to go into the market
Well,
and
it does
claim damages from you.
in that instance, yes.
Right.
Yes. Of course, there are... maybe we're at cross purposes, my lord. All of it does in the sense that it limits. They can go out, but what they can recover from us is limited, according to this.
Well, no, they have to pay you something.
Yes, in year 8, they do, but then it's lasted for 8 years, and they get a discount. And it reflects, I submit, the reality that one needs to read these meters.
It reflects the reality.
The reality that one needs to read these meters, my lord. So one of the oddities of this case is that one would have thought in the ordinary case that you buy AMR modules for the purposes of reading these meters, and when they fail, you would seek potentially a replacement under this scheme, and then it would be remedied. Now there are a whole host of reasons why not, no doubt, which can be explored at trial. But the reality is that these meters and modules have now been installed for years, not operating according to the claimants, or at least the AMR module isn't. And now, rather than seeking the replacement, they seek a large monetary sum, a cash sum, even though, on their case, it's not clear that they will ever replace the meters. But the way this case really works, the way we put it first instance, is that that is the long and short of it. And this scheme would have allowed SEW to obtain what they bargained for, namely working AMR modules. It's just that now they want a large cash sum to reflect the market value of replacement devices, and that's what the parties agreed they couldn't have. And it may be that SEW don't like the bargain now, but that is what we say that the words mean, and we do emphasise example 2. How can it be the case that they can have damages for the full value in year 8 in the light of example 2?
So I understand that broad
Yes.
proposition, but so can we?
Yes.
You say that Schedule 11 is absolutely clear. The words are very clear. Can you taking us through the words of Clause 11?
Yes.
Or Schedule 11. How does that work? How is it to be read?
Yes.
Giving South East Water in the year 8 example an obligation to pay you. That's what it does.
Well, it's not an obligation to pay us. It's an option on their part to pay us for a replacement device at a discounted price.
But I think you said it doesn't prevent them going into the market and sourcing alternatives.
Yes, but they just can't sue for damages from us for that value. Obviously, nothing prevents them, but the question is, are my clients liable for it? And the answer is no, because our liability is limited by this. And so, in the Year 8 example, I say all they have, and I don't mean to undermine the protection that they have. They actually have, in my submission, a significant protection, which is 8 years after this module has been installed. And these are, we can go to the figures, but they're £50, £100. They're not very, very expensive items. At 8 years after being installed, they can get a replacement, and they don't have to pay market value. And the replacement that they will get will, in the ordinary course, have another 10 or 15 years of life. So they get a benefit. They get that at 47% discount of the purchase price at the time. Now, in answer to my Lord's question, it may be that they choose not to exercise that right. They don't want it. Mm-hmm. It may be, as Lord Justice Mayall said, that they don't really trust us anymore, and they prefer an alternative supply. Well, that of course is open to them to go and do. But what they can't do, in my submission, the parties having agreed this scheme, is come back to Elster and say, by the way, I want the full market price of the...
Right, and so on that analysis,
yes,
they have sourced an alternative supply.
Yes.
Reading the words of Schedule 11, how does it work to limit their claim against you?
They have, well, the cost of a replacement device, so the cost to them of a replacement device, any incidental cost, or the cost to us, and I think your Lordship is looking at it, the cost to us. It's
well,
not just
I want to know how you read the words.
It's not just the cost to us in terms of supplying it, it's the cost to us in terms of liability in any action.
Well, that's what I want to understand.
Yes, I say it goes to my client's liability now, as well as the cost to us of supplying it. It's also broad. It's broad. It means the cost to us of a replacement device, and that's why I went back to the pleadings.
Sorry, who's us then?
SEW. Sorry, Elster. Yeah, that's why one does have to look at the pleaded case carefully, because SEW are seeking the costs of exchanging or replacement devices from Elster. That is the pleaded case.
Yes, they're seeking the cost of replacement in the market from you.
Yes, exactly. And all I say is that the costs of a replacement device on our part, and we're the ones having to pay the bill if we had to pay a damages claim, are limited. That's how I...
But to what? Because you're not, on this scenario, supplying a replacement device. Therefore, the cost to you of supplying a replacement device is zero, because you're not being asked to do it. So is it the cost which you would have incurred if you had been asked, or what is it?
Well, it would be. If we're talking of what damages there would be for breaching Schedule 11, it would be the cost, we say, that we would have incurred if we'd had to supply it. So, but that's a different...
Sorry, who's breaching Schedule 11?
I'm sorry?
The cost, you say, is damages for breaching Schedule 11? Well, who's breaching it on this scenario where they have simply gone out into the market to get another...
If they've gone out to the market to get a replacement, and let's say they've incurred £20 million doing that, and to follow your Lordship's question through, I think your Lordship is saying, why is that a cost to Elster? Mm-hmm. Is that your Lordship's question?
Yes.
Well, if my clients are liable in damages for that cost, then it is a cost to Elster, in my submission. And it's wholly artificial with respect to split the two. That's not how a commercial party would understand that. I mean, it would be no good to say to Elster, let's just speak to a business person and suggest that, by the way, SEW have gone out into the market and they spent 20 million on the cost of replacement devices. And Elster say, well, I'm not paying that because the costs of a replacement device are limited to this. The answer can't simply be, it may be a legalistic answer, but it can't be, say, well, it's not a cost to you. Well, it is if Elster are picking up the tab for it. And that's my submission. And this is why the judge thought it was very clear. It has the benefit of being drafted in sort of lay language rather than overly lawyer language. That may lead now to a debate, but the reality, we say, is that the scheme is clear. The parties had put their minds to these examples, and it would be wrong, I submit, to rip up this and say that somehow Elster are liable for the costs of replacement device that go beyond this warranty. That's not how commercial people would approach this this contract.
So the answer to my lord's question is what? On the assumption that Elster are not replacing
Yes.
the AMR units because SEW have gone out to the market.
Yes.
So there isn't, however it would work, whether a request or an obligation, whatever, that Elster are not providing AMR units. Is it limited? Do you say it's limited, that your client's liability is limited to the cost to you of the AMR units?
Yes. Of course, at year 8 minus the discount.
Yeah. I was going to say. So limited to the cost to Elster of the EMR units, and after year 5, so from year 6 onwards, less whatever the discount would have been.
Yes.
Yeah.
So I was dealing with example 2, and your lordships have my submissions on that. So there are a number of points just at the end of this section 2 of my submissions, which deals with what I say is the natural and ordinary meaning. There are a number of points that SEW make, some of which were not pursued in oral submissions. I'll take them very quickly. The first is that they submit, this is para 23.3 of the skeleton, core bundle at 12.135, that Schedule 11 did not state that it took precedence over the terms set out in Schedule 2 or excluded or restricted rights under the Sale of Goods Act 1979. And I say that is wrong on the clear words. Schedule 11 said in terms that the costs of replacement would be limited to the warranty. And we say the effect of that is, insofar as the other terms of the agreement would, absent Schedule 11, have entitled South East Water to a greater recovery in respect of the costs of the replacement, then the recovery was expressly limited. There was a point which I don't think is now pursued in the same paragraph of the skeleton, that Schedule 11 did not form part of the contract as defined in condition.
Well, that's not pursued because primary submission is reconciliation of
exactly
Schedule 11 with the rest.
The third point was that Schedule 11 does not use the words damages. So therefore, it does not have the effect of restricting a claim for damages for the costs of replacement. And I submit that that is an unreal submission. If your lordships are with me that this isn't an optional warranty, then the fact that Schedule 11 doesn't use the word damages is no answer, I submit, to Elster's case. As the first instance judge found, Schedule 11, well, commented, is obviously a short provision, not drafted in lawyerly language, focusing specifically on the costs of a replacement device. And I submit the parties, and this is by reference to the words, cannot have intended that the parties could ignore the limitations in Schedule 11, if indeed that's what they are, and on my submission they are, by claiming damages, by simply recharacterising the claim for the costs of replacement. Obviously, if you're limiting the costs of replacement, you are, in my submission, limiting Elster's liability for damages for the costs of replacement. It would be highly artificial to separate the two, because in economic effect they're the same. In answer to Lord Justice Zacaroli's point, if you've gone out into the market, you've spent 20 million, and you come to court and ask for Elster to pay damages for those costs of replacement which you've incurred in the market with third parties, I submit it cannot be sensible to say that my client's obligations to repay the costs of those replacements have been limited if Elster are actually paying damages to the tune of 20 million.
I think I understand your point to be that how Schedule 11 works in the example 2 scenario is that the amount of Elster's liability to you is limited to what it would have cost it had it complied with the warranty.
Yes. Elster's liability to SEW, yes.
So that is the cost of the replacement item that it would have had to have paid for,
Yes.
minus the discount.
Yes.
That's what it would have ultimately cost it
Yes.
had you claimed out, had it complied with the warranty, had you sought it to comply with the warranty.
Yes, I think that's right. Without sort of writing down, that is definitely right in the sense that we say it's limited to the cost of us complying with this warranty. So Elster was aware of what it would cost them. And if they've got back-to-back contracts with suppliers and they've got a certain price for these AMR modules, they know that they have to provide a free of charge replacement and therefore have to get it from their supplier at a certain cost. So they know what their liability is. And there's nothing, we say, commercially odd about this. I mean, it's one of the points that's taken against us. Somehow it's commercially absurd. We say the reverse because, and I've made the point a couple of times, but SEW, one would have thought, are interested in obtaining working AMR modules. And this scheme provides working AMR modules. Now, I take Lord Justice Mayall's point. It's a separate point that the party might not have contemplated, that what if this all goes wrong? And my answer in part to that was it's not going to go wrong a second time, or likely won't go wrong a second time in a realistic world. But that is the scheme.
So in year 1, the damages claim against Elster is limited to the value of the unit, essentially, because whatever it would have cost it to buy it.
What would ever have cost Elster to buy it?
Plus £40.
Plus £40, yes. But of course, we're talking in terms of, because we've got to this stage of the litigation, and we have got to litigation in terms of damages. But in a normal sense, one would have thought, you read this when you're signing the contract, you think, well, that's fine. Year 1, I ring up, you just get a free of charge replacement and £40 instalment. Whilst that's what was agreed. I submit that the parties aren't thinking necessarily of what's my damages claim in the event that they don't provide a free of charge replacement. But the answer to it is it must be, and this is open to my learned friends' debate subsequently if the pleading is re-amended, what the damages are. I mean, that's not actually an issue in this appeal, but I accept that it informs the analysis to a degree. We say it's limited to the cost to us.
How does it work if the liability is limited, as you say, to the cost to Elster if it complied with the warranty? Elster has its own supply contract, as I understand it.
Yes.
Does the cost to Elster of complying with the warranty depend on what the terms of that supply contract happen to be? For example, you may have done a really good deal, which the supplier says, if anything goes wrong, we'll give you one free of charge. Or they may have may find they haven't done anything and they have to go out into the market themselves and find a replacement. So how does it work?
It would depend on the cost to Elster of complying with the warranty. So that would be.
So if they happen to have done,
determined on
so
the
if
price.
they happen to have done the good deal, that they could get one free from their supplier, the cost of complying with the warranty is zero, and therefore Elster has no liability at all.
Well, in a damages claim, but of course that we are liable to provide a working free of charge replacement.
Yes.
So SEW wouldn't need to concern itself with the damages; they could just get the free of charge replacement.
Well, I thought you were talking about what are the damages for failing to comply with Schedule 11. I thought that's what you were saying.
Yes, in discussions we were talking about the damages for failure to comply with Schedule 11, but this is the problem of, if I may say so, and of course one needs to grapple with it in the round, but.
You'll say this is lawyers asking questions businessmen would never.
Well, I do say that. I'm afraid, my lord. But I do not, with the greatest respect. I think one, as the court will do, has to approach this in a commercial way, as the court will do. But I don't think those are the sorts of questions which would have been troubling the parties at the
You may have put your finger on something, though, Mr. Power, when you say that. At the time that this was done, a device goes wrong, so it's a very convenient way. Here's the free of charge replacement, £40 contribution, and so on. And you said that the parties had thought about that, and hence Schedule 11. But they might not have been thinking about the damages claim. and so there's there is a point that this is the practical stuff,
Yes.
and then the potentially catastrophic consequences aren't here but are in Schedule 2.
No, I don't accept that, my lord. But I see.
Well, I didn't
that's the
expect you
point.
to accept
Yes,
that.
yes.
I'm
It'd be
just
surprising if I did.
ruminating out loud as to picking up your submission that the parties weren't thinking of the damages claim, and obviously they weren't to that extent, because we're exploring how the damages claim would be reflected in this. So I just wondered if that was a potential point of distinction.
Well, I don't accept that, my lord, because of what we say the clear wording of Schedule 11. The reality is they'd agreed the scheme for the faults identifying in operation. There's no distinguishing between the numbers of modules that failed. I mean, it's not suggested if 2 or 10 or 1,000 fail, example 2 applies, but if 100,000 fail, example 2 doesn't. There's just no distinction. And it may be, this is why one gets into the primacy of the language, because I think I cited Arnold and Britton earlier, so your lordship has the reference, but it's obviously very well known. But you can go through the weeds now of what the parties might have contemplated or thought, or what would have been good for them to think, or whatever. And I submit that's really quite unhelpful here. One is left with the bargain that they struck, and this is the bargain. And as your lordship, you weren't noting, but putting it in your question, picking up on my submission, that this is a practical commercial solution. And when I say that the parties didn't contemplate the damages, I don't mean that they didn't prescribe what the consequences were, such that we can now assess what the damages would be. I'm just meaning factually that I suggest it's unlikely that the parties would have been thinking in terms of damages. They were thinking in terms of, what replacements do I get? What will it cost me to get replacements? Because I need working meters. And then it's for lawyers, obviously, to work out the damages claims in the event that this scheme isn't followed, which obviously the pleaded cases isn't following this scheme. But what it's absolutely...
On the basis of the pleadings, it appears that the scheme was followed for a bit, in the sense that SEW got Elster back, and that eventually led to the supplemental deed 5 years later. So there was, as at 2015, it appears that there was commercial contentment on both sides. And so to the extent that it's pleaded that there were things that weren't working in the first couple of years, I've assumed that those were either put right or were not sufficient to concern SEW, hence the supplemental agreement deed. Yeah. Is that it on Schedule 2? Sorry,
I think it is,
Schedule
my
2.
lord. Yes, so you have my submissions on the meaning. I don't think I need to remind your lordships by reading it what the judge found, but it's paragraph 101 and 103 at core bundles 64 and 65. We would ask the court, obviously, just to remind oneself precisely what the judge said. The judge had a very distinct impression that these were clear words, that this was a commercial scheme. Maybe worth actually having said that. I don't need to turn it up just to anchor ourselves. It's page 64. And And his lordship's view at 64 at paragraph 101 was it's frankly hard to see how its wording could have been improved in terms of conveying its intended effect to the intended reader. The intended readers obviously being commercial people dealing with these AMR modules. It has the undoubted merit of simplicity and clarity instead of being concealed in a thicket of legal boilerplate. Example 2, I know I bang on about this point, but example 2 is a very clear, commercial people can understand, not they wouldn't be able to understand it otherwise, but one has the point that it's straightforward.
So what he says it means is it's limiting SEW's entitlement to the cost of an equivalent replacement device. I think you say it, well, a few moments ago I thought you said it's limited to the cost to Elster.
Well, there are two distinct points to the argument, if I may say so, my lord. There is what it means in terms of the limitation on the liability of Elster to pay damages, if you want to put it that way, for the cost of replacement. And we say it's absolutely clear that that clause means that Elster is not going to be writing a cheque for the price that SEW obtain in the market to replace all of these because it's limited. And then there is a separate question which the judge identifies is if you don't follow this scheme and if Elster don't provide a free of charge replacement or SEW don't ask for it, what is the damages claim? And that's at 129 of the judgment at 69.
So sorry, in 101 he's saying is it works by limiting their entitlement to the warranty.
Yes.
Right, not to anything else.
Yes. My lord, I turn to head 3.
Sorry, you were taking it to 129 for the damages.
Sorry, my lord, yes. 129 is at page 69. This is where the pleading with which, the paragraphs of the pleading with which we're concerned, are struck out. And the judge poses the question which arises is whether or not SEW can maintain a damages or other monetary claim based on the failure to comply with the Schedule 11 obligations or on the claim being limited to the cost to Elster of complying with its Schedule 11 obligation. That is deeper water, I submit. It's not the waters for this appeal. I submit that it's the water one has to go into when we get a pleading that is limited to Schedule 11. And that's what the judge thought.
So to be absolutely clear then,
yes,
the judge found, do you say, the judge found that the effect of Schedule 11 is to limit SEW's entitlement in any case where there is a defect, a fault in operation, to the operation of the warranty. That's its only right.
Yes.
So it can't claim damages, can't go into the market, and if we can do, but it can't claim anything from you.
No, we can claim damages for breach of Schedule 11, but...
Well, but we're not talking about a breach of Schedule 11 yet. It
just
chooses not to operate Schedule 11. It has no claim against you, and its only entitlement is the warranty in Schedule 11.
Yes. But we say that's not, I submit, unsurprising or odd, because this is not a case of a... we'll come to this in a moment, but I can deal with it now. It's not a case of a limitation clause which is excluding something one would expect to get from the contract. You know, that we've had recent cases, many of which your lordships have addressed, where you're excluding lost profits or wasted expenditure or whatever. So you're taking out a fundamental core of what you're entitled to get under the contract. Whereas Schedule 11 does the reverse. It puts front and centre the AMR module and your ability to have a working AMR module for a duration of up to 15 years. So to talk of it in terms of limitation is correct legally, but it's also just a practical solution to faults arising, which gives SEW what they bargained for, namely working meters. I mean, it's not, one labours the point perhaps, but at page 113, I mean, for the first 5 years, they're getting a free of charge replacement. No commercial person, I submit, would find that really a limitation. They're getting a what they bargained for.
there seem to be three different measures that the judge is talking about now that you refer us to these paragraphs. So in paragraph 101, he's saying that SCW's entitlement is limited to the cost of an equivalent replacement device. Well, that's what they say they're claiming. But
sorry, I'm not sure I followed that point, my lord. That would be my fault.
He says, makes it quite clear that Schedule 11 has the effect of limiting SEW's entitlement to the cost of an equivalent replacement device. Well, that's...
Yes, although he goes on, this may be Lord Justice Zacaroli's point as well, and the answer was, and any incidental cost to the warranty set out below.
Yeah, I
think that was
where
we got to, yes.
But then in paragraph 129, he envisages two possible ways the claim might be put. One is a failure by Elster to comply with its Schedule 11 obligations.
Yes.
Well, I don't see how that can arise unless you've been asked to comply with them and haven't done so.
Well, the judge at first instance, that was the submission I made to the judge, but the judge didn't find that an attractive submission. I recall that the judge thought that there was an argument to say that in the particular context of building contracts and so on and so forth, that one could just choose to sue for damages anyway. That was certainly my submission, that one would have to ask for it, but that was the answer.
And then, if they haven't asked for it, then they're left with what is the judge's final possibility, which is limited to the cost to Elster of complying with its Schedule 11 obligations, i.e., if we had been asked to do it, then this is what it would cost us, which I think is what you're saying.
Yes, and we say, well, what's wrong with that? It's a perfectly commercial bargain to strike. I mean, you get your free of charge replacements. If you don't ask for it and you sue for damages years down the line, then why should it be the case that Elster has to pay the full market value of the replacements rather than it being limited to what they would have incurred had they provided the free of charge replacement when requested to do so? There's nothing odd about that at all. We say that's what the words say, and that is the bargain that the parties struck.
Yeah, thank you.
There were 5 headings. This makes it sound longer than it is, don't worry, my lords. There are 5 short points, as it were, as to under my third heading, which is points that I've characterised as being...
Hang on, I've got to find your third heading.
Third heading, yes. So there were 3 at the outset, my lord. Third heading is the point that you shouldn't give effect to what we say is the clear and ordinary meaning of the words in Schedule 11. There's sort of a bag of points which includes the irreconcilable and general and specific point. But I'll take the first one quickly, which is the point they made at ground 2.2. This is core bundle 14. Just see the ground, but that Schedule 11 was only practically workable and only made commercial sense if it is construed as a collateral warranty. And I've dealt with this already, so I don't need to labour it. We say the reverse is true, that Schedule 11 is a practical and sensible agreement between the parties as to how to deal with faults identified in operation for the reasons I've identified. And it is said in this regard by SEW that why would they agree to a limitation without being able to quantify in monetary terms what their future claims would be limited to? That's para 39.1 of the skeleton. And I submit it's unrealistic, a point I've trailed before, to suggest that commercial parties such as these had in mind what monetary damages they could claim for in the event of the AMR module failing. Instead, they were interested in getting actual replacements so that meters could be read remotely. And in any event, SEW must, I submit, have had a reasonably good idea of the cost to Elster of supplying replacements. It knew what the units were being sold at. It could make certain assumptions regarding that information. But in any event, that wasn't the focus, I submit, of what the parties were dealing with. it is said in this heading of it being practically unworkable and uncommercial that Schedule 11 overrode to a degree SEW's right to recover damages. Well, I mean, that's not commercially absurd. That is the nature of a limitation clause. And we also say it's difficult to see how it can be said that Elster's construction is not commercially sensible, given the judge's conclusion, in respect of which permission to appeal was refused, that Schedule 11 would have satisfied the requirement of reasonableness under UCTA had it applied, and it didn't apply because these were not standard terms. But the judge was of the view that there was no real prospect of SEW showing that Elster would not satisfy the requirement of reasonableness, and permission in respect to that was refused. So then we come to the second point, which is really the thrust of these submissions made by SEW, which is that the Schedule 11 is irreconcilable. Now, of course, it is said it's not, that they're consistent, but there's a sort of waterfall of points which I need to deal with. We also say, as Lord Justice Coulson notes, that the clauses are not irreconcilable. My learned friend took your lordships to the Pagnan case, Lord Justice Bingham, as he then was. There's no need to turn it up again, but just to remind your lordships that, as Lord Justice Bingham said, it is not enough if one term qualifies or modifies the effect of another. So qualification and modification is not enough. To be inconsistent, a term must contradict another term or be in conflict with it, such that effect cannot fairly be given to both clauses. And we say that the conditions at 13 and 5 of Schedule 2, so the indemnities and the remedies, they are, on their face, general provisions. They apply in respect of all manner of breaches which could occur under the contract. They apply, for example, to short delivery, no delivery, delayed delivery, catastrophic fire, so on and so forth, to everything. They are plainly not to be taken as the final word on the remedies that a party has. Lord Justice Mills rightly, if I may say so, noted that there is a provision which says that the contract can be rescinded if any of the products are faulty. And we do submit that if that was the submission being made, that this contract had been rescinded because one product had failed, that is not a submission which your lordships would be keen to accept. I mean, it cannot have been the intention of the parties that just one faulty product would mean you could tear up this contract. And so what I say that Clause 13 means is it's a preservation of the ability to seek these remedies, notwithstanding that you've accepted the products. And that's what the words say. I pointed out when I went through it, your lordships will have noted that it says notwithstanding, or something to that effect. Let's just get the precise words rather than me paraphrasing. It's whether or not the products have been accepted by the purchaser. It's general, it's with respect boilerplate language to capture the fact that whatever remedy, that acceptance isn't going to forestall their ability to sue for damages, that taking one option rather than another will be without prejudice to the other, and so on and so forth. I do submit that it's not a fruitful place to try and find the answer to this case in light of the specifics of Schedule 11. The fact that there is a limitation on the damages recoverable does not render Schedule 11 and these provisions inconsistent. And your lordships have my point on the fact that Clause 9.4 qualified or modified the ability to obtain damages, and so does Schedule 11, and that is what I submit your lordships should decide. I mentioned it earlier, it is said, para 42D of my learned friend Skeleton, that the effect of Elster's construction of Schedule 11 is that SEW does not have a discretion to choose which of the remedies. I submit that's not the case. They have chosen a remedy, namely to sue damages. And the question is, to what extent is that qualified or modified elsewhere? My Lord, there's a reference at para 41 of SEW's skeleton, which suggests that the right to recover damages in accordance with the measure set out at section 53.3 of the Sale of Goods Act was restricted, and we've canvassed that point already. There's no pleaded case to diminution in value, and I've given my answer to Lord Justice Zacaroli's question as to what we say will be the answer if and when such a case is pleaded. Namely, you can't because of Schedule 11, and if you can, Schedule 11 gives you the diminution in value. Example 2 being the classic point on that. It would, I submit, be odd for a court to conclude that the diminution in value was different from what the parties had ascribed to it in Example 2. So I submit there's no inconsistency. But if there is a simple answer on our case as to how one resolves it, and it is relying on the principle that the specific trumps the general. And in that regard, I said I wouldn't refer to much authority. I will take your lordships, if I may, through briefly the Yarm, Road and Hewden case, unless your lordships have read it in full and don't need any assistance on it. You know, no doubt you can tell me if I'm going too slowly and I've read it or digested it, but it's at tab 5. We do say that this has striking similarities to this case because there was the general indemnity, and then there was the specific provisions, and the specific trumped the general. If we start at page 85, this is the decision of Lord Justice Laws, and just to anchor ourselves, Lord Justice Laws dissented on the question of the main appeal, but on the cross appeal with which we are concerned with, or on which I rely, Sir Martin Norse and Lord Justice Pill agreed with him. So whilst it's a dissenting judgment, the passage which I rely on later is a judgment with which the rest of the court also agree. So paragraph 2 sets the context. The action arose out of the collapse of a tower crane, referred to as TC3, at the site of the new HSBC headquarters in Canary Wharf. In paragraph 2, one can see that the tower crane had been hired by the first claimant, Yarm. So Yarm are the hirer, and they'd hired it from Hewden, the defendant. And then if we could go to paragraph 4, page 85, it talks of the terms of the contract between Yarm and Hewden. And the second sentence, it is common ground that the contract was contained in or incorporated a number of documents, including 6 in particular. And I just note the KCB terms and the CPA conditions in the next sentence. And then we look at this general indemnity, which was in the KCB terms. That's at page 86. And that forms the basis of the cross appeal. The indemnity provides that the supplier, that's in this case Hewden, shall indemnify the purchaser, Yarm, against any loss or damage, including any claim made by any third party and any associated costs arising out of the performance or failure to perform this purchase order. And at 16 it says, unless otherwise agreed, the model conditions apply, unless otherwise agreed, and these model conditions are the CPA conditions. And then one sees at page 87, clause 13 is the specific provision in the CPA conditions, which deals with the hirer's, that's Yarm's, responsibility for loss and damage. And the general, I said it's specific, but the default position is 13b, that the hirer shall, subject to the provisions referred to in subparagraph A, make good to the owner all loss of or damage to the plant from whatever cause the same may arise, and fully and completely indemnify the owner. And then C, notwithstanding the above, that the hirer shall make good to the owner shall accept liability, so Hewden shall accept liability, for damage, loss or injury due to or arising, and it's 2 that's of interest, during the erection of any plant. So that's the context. At paragraph 5, there was a preliminary issue directed by his Honour Judge Havery, and that went to the question whether Hewden were liable to Yarm by that clause 13C2 during the erection of any plant, or whether it was the other way around and that Yarm were liable to Hewden by the default position, as I've called it in 13B. Now, the judge found in favour of Yarm on issue 1. That's paragraph 13. He found that Yarm, the hirer, could rely on the contract, on that provision, 13C2, to make Hewden, the owner, liable for what had happened. He concluded that the accident occurred during the operation of the climbing of a tower crane, which, in his view, was during the erection of any plant for the purposes of that clause. And that's what the main part of the appeal was about, and Lord Justice Laws disagreed with the judge on that point, but Sir Martin North and Lord Justice Pill agreed with the judge that it did occur during the erection of any plant, and for that reason the owner, Hewden, had to accept liability. So Yarm didn't need their cross appeal, but they did have a cross appeal, and it's that, if you can forgive that somewhat lengthy but necessary introduction, that concerns us, and it's this, at paras 40 and 41 on page 100. So Mr. Williamson for Yarm had said, if I'm wrong on the erection of the plant point, if I'm wrong that Hewden are liable under that, then I want to rely on clause 11 of the KCB terms. Now that's the general provision that I took your lordships to, which, just to remind your lordships, is at page 86. And that's clause 11, the supplier, so Hewden shall indemnify the purchaser, Yarm, against any. The sort of general wording. And there was a debate about how it was incorporated, which was discussed, but then in the middle of para 41, it's this I rely on. Lord Justice Laws took the view that the two set of conditions, so that's the specific 13 2C provision and 11, can be read consistently if the clause 11 indemnity is taken to apply to the extent that the parties have not agreed otherwise, and such consistency is to be obtained if possible. Thirdly, and we do emphasise this, such a result is further supported by principle, since whereas the clause 11 indemnity is perfectly general, I say that's your clause 13 in the framework agreement, clause 13, schedule 11, is dealing with the distribution of contractual responsibility in the specific context of the hiring of plant. And the rule, crisply expressed in the Latin maxim, is that the general is taken to give way to the specific. And we say...
I was away when we did Latin maxims.
That's
so
why I decided...
Whatever principle I shall be crisply expressing, it will not be in Latin.
Well, I didn't read it out for fear that my pronunciation would be poor. But,
well, my lords may be able to check the pronunciation, but I'm afraid that is definitely beyond me.
I could have given it a go, but it would no doubt been butchered. So I rely on the English. So what Mr. Williamson was saying for Yarm was, okay, I may have lost on the specifics of the CPA conditions, which say that Hewden would be liable if the crane was in operation. But I'd like to rely on the general indemnity, which surely gives me the right to sue damages. And Lord Justice Laws and the court were having none of that for the reasons I've just identified. And I do say one can immediately see the similarity of the approach in Yarm and what the facts of Yarm indeed, and the arguments run here, because what is said is that whatever the specifics of Schedule 11, one has to read the runes, as it were, in the general words of Clause 13, and that is carrying a great deal of weight, whereas the parties, in reality, dealt specifically with this scenario in Schedule 11, and if there is any inconsistency, we say there's not, it just qualifies or modifies Clause 13, then Schedule 11 must trump. And I'm getting there, my lords. We've still got some time. What I thought was being said, although I don't think it's pursued now, is that if your lordships got to the stage of it being inconsistent and needed an answer from SEW as to which to prefer, I think your lordships don't really have an answer there. I mean, we've given the general specific answer, but I don't think there's an option on SEW's side once one gets past the limitation approach to limitation clauses. But we had thought that they were saying that there was an order of precedence term in the framework agreement, clause 3.
The difficulty with that is that the judge said no, and they haven't got permission to appeal on that.
That's right, and your lordship, I think, dealt with that in yes.
But one thing that I'm clear about is that clause 3 is not an order of precedence clause.
I agree, my lord, respectfully. So that ends that.
So that is a canard mort.
That ends that. So
your lordship
for French.
clearly your lordship attended French.
Yes, I picked up. I was there that day. Yeah.
There you are. And so therefore we say the judge was right. He dealt with the inconsistency point at paragraph 104, which we've seen already. Mr. Darton went to it, core bundle 65. Point C of my 5 little headings under part 3 was the utilities procurement background. I'm not going to trouble the court with that. I had some notes on that, but unless it would be of assistance. The short point is there's no evidence to support what is alleged at paragraph 44 of the skeleton, which is at page 144. This is how high SEW have to put the case and do put the case. They say that the parties, quote, cannot objectively have believed that Schedule 11 was a provision limiting Elster's liability because of the procurement background. And we say there's just simply no evidence to support that. This was a negotiated contract where we were putting forward a schedule. It was agreed. So it doesn't get off the ground. As I say, I had some more notes on that, but I don't think that's pushed that hard. There was a point D was the suggestion that the manner in which Schedule 11 was introduced in negotiations suggested that this was inconsequential. I was going to submit very quickly, obviously that's rather heretical that one can look to pre-contractual negotiations as an aid to construction, and I don't think it's suggested that by Mr. Darton that the court should do that. So I think that point also goes. And then the only remaining point, which I've dealt with really already in terms of the substance, is E, that the judge failed to apply the stricter test for the construction of limitation clauses and did not give sufficient weight to the fact that Schedule 11 would restrict SEW's rights. We say that that's wrong. There's no dispute about the principles when considering limitation clauses. There is, I think, in the words of Lord Justice Coulson in a recent case, a confluence of 2 principles, namely the natural meaning of words and the need for clear language to exclude an obvious remedy. A summary of the principles is in the recent EE and Virgin Mobile case, paragraph 16, Authorities Bundle, tab 12, page 288. And what I say here is simply that the wording of Schedule 11 is clear. We say, in truth, it's only capable of one reading without adding further words to it. The judge found it was as clear as one could hope for in terms of language and effect. And whilst we've debated it today, I do submit that when one comes back to the words, one is left with the fact that they are clear and that Elster's case gives effect to those words, whereas SEW's case involves rewriting the bargain. But the second point on clarity is this. The second point to add to the clarity point is, that's my final point. This is not a case where Schedule 11 has any extreme consequences. On the contrary, Schedule 11, far from removing the obvious remedy, namely the replacement of a defective product, expressly provides for a replacement. It enabled SEW to obtain a free of charge replacement for 6 years and thereafter discounted replacements for up to 15 years, so beyond the 10-year specification. And therefore, there's no reason in my submission to give the language of Schedule 11 a strained construction in the manner suggested by SEW. I have nothing further, my lords. Obviously, I'm happy to answer any further questions that your lordships have.
No, thank you very much, Mr. Pine.
Thank you.
Yes, Mr. Don.
My Lord, just a few very brief points in reply. Dealing with the point of, as it were, catastrophic fault in the products. Under the trial judge's findings, those would be excluded. And the safety valve, which I think my Lord Justice Coulson raised, of if it was reasonable to invite the contractor back, is not engaged at all. So under Schedule 11, if it means what the learned trial judge said it meant, even if we have perfectly good grounds to not want a replacement product, which is supposed to be an equivalent, because we have no confidence in the respondent, we're debarred from that. So I may have set the hair running there with the reference to Pierce, Baxter and High about how you look at damages in a JCT context with the right of the contractor to return. But the point is, as my Lord Justice Coulson pointed out, is you're not obliged to invite the contractor back if you've got good reason to not want them, as it were. Whereas here that will go all together.
It depends, doesn't it, on what the respondent's case is. If the respondent's case is the only remedy you have is to enforce the warranty, then you'd be right that you can't take a replacement. But if their case is, as I understood it to be, at least as an alternative, and I'll be corrected if I'm wrong, that the liability of Elster under Schedule 11 is limited to what it would have had to pay had the warranty been enforced, then you're not shut out altogether.
I don't believe that is their pleaded case, my Lord. I believe their pleaded cases are only remedies under Schedule 11. And I think that is dealt with in the defence. So if one goes to page 94 of the core bundle, paragraph 26, my lords, of the defence.
'94.
94, my lord, yes.
Paragraph
26, my lord. And also there's paragraph 6, so I don't think the point is made quite as clearly there, but I say it's the same point at page 90.
Quite sure what it means to say the defendant has complied with its obligations under Schedule 11.
So
nothing's happened yet. There hasn't been a request for replacement yet.
No, but so there could be no claim. There could be no claim because you haven't triggered the obligation. And if one looks at the judgment, the learned trial judge, he doesn't, on my recollection of that paragraph in his judgment, he doesn't say you could be entitled to the cost of damages based on the cost to Elster. He says you might be able to, and I'll leave that to be resolved. So if you go, I think it's right at the back of the judgment. This is paragraph 129 of the judgment, my lords, at page 69. And although he suggests the question is left open, I have absolutely no doubt that had we sought to reformulate, we would have been met by the argument that at the paragraphs 101 to 103, I think it is, the learned trial judge says, I agree with the respondent's construction of Schedule 11. And were one to have a wish, and I'm not encouraging it to go through the transcript, as I say, I think it was myself who set the hair running by referring, as I have done in this court, to the case of Baxter and High. So it is Schedule 11 or nothing. And you can't have breached Schedule 11 if Schedule 11 hasn't been engaged. Which of course begs the question, how does Schedule 11 become engaged? Because one would have thought it would have been on us making a request, but Schedule 11 is silent on that. So then we would submit, you go back to Schedule 11 and say, well, does that mean that SEW has an option? As set out at 13.13. Well, my lords, so I do say that that is not, what is clear in my submission is that is not the judge's interpretation of the clause. He's saying it might be possible to recover those damages as a breach of Schedule 11.
Or on the claim being limited to the cost to Elster of complying with its Schedule 11 obligations.
Yes, but I hope I haven't misread it, but he hasn't, says I haven't decided that.
Well, he can't because there's no pleading with that claim.
No.
So that we can't criticise the judge for that.
No, I'm not criticising him. What I'm submitting is that he's not saying that is a possible construction of Schedule 11. I would submit what he's actually saying is...
Well, he's saying it may be a viable way of putting the claim that is in accordance with Schedule 11.
Yes. But
So,
the plain meaning...
So it's Schedule 11 or bust, but the question is what Schedule 11 means, which we've spent today debating.
We have, and of course without... I of course, say the longer the debate, the less clarity. And I know that doesn't necessarily...
Well, the difficulty with that argument is that commercial barristers can waffle for Britain about provisions that judges think are plain and obvious. Whether this is that case is, of course, a completely different matter. But length of submissions does not equal lack of clarity. Can do, but it's not a given.
In that regard, my lord, I will be brief.
Oh, that wasn't a criticism of your submissions. I'm simply saying that you can't make that easy equivalence.
No, my lord, I don't, but I've made my point there. And
You've made your point. I mean, we fully understand your point about absence of clarity, that the absence of clarity to have the effect for which Mr. Power contends. We understand that.
And so there's just two further things I'd like to say in that regard. And that is, one, even if the Yarm Road, the specific gives way to the general applies, if the specific is a limitation clause, it is still subject to the test for a limitation clause. That's the first thing. And the second thing, with some trepidation, your Lordship asked me, and I failed to give a conclusive answer, but my learned junior was desperate to prove me wrong, the sort of the last redoubt if all else fails. And that is in our supplemental bundle at tab 13, we have Lewison, of course. And there...
Hang on a minute, in the authorities?
Supplemental bundle, my lord.
Supplemental bundle?
We have a supplemental bundle of authorities because we only went for the... Well, we went for 11. I think we should have gone for 10. But then we agreed that we probably might need the others there. Sorry? Oh, my lords, I'm so sorry. We haven't filed it.
Right.
I thought we had. That's my mistake. But in any event, at page 628 of Lewison, under mistake...
We haven't got that.
No, my lord. Do we have copies? We've got copies, my lord, if this is.
Well, I'll obviously give Mr. Power the opportunity
Of course,
to
my lord.
respond, but if you've got copies just of the bit of Lewison that you're
Yes.
relying on.
I'm so sorry. I didn't realise we hadn't put in the supplemental bundle, so I was sort of...
I don't want a supplemental bundle, I just want the bit from Lewison you're relying on.
You just have to have it. Sorry, tab 13, you're quite right. My lord, shall I just hand up mine?
Well, the learned associate is poised.
I'm so sorry, I do apologise. I take all the blame. But
So it's paragraph...
well, it's really under 8, page 628 of the pagination to Lewison on interpretation.
Pages which, sorry?
628 of Lewison. Lewison. You've got internal inconsistencies. So it'd be 210 on the bundle, the supplemental bundle we failed to hand in.
210. I've got paragraph 9.7.4, then as heading towards the bottom, internal inconsistency. Yes. Right? Yeah.
And we say that's the point that would be engaged. If a clause in a contract is followed by a later clause which destroys the effect of the first clause, the later clause is to be rejected as repugnant, and the earlier clause prevails.
That has been described elsewhere as the unutterable bottom of the barrel in terms of canons of construction. I think Lord Newburger may not have used precisely those terms, but it's along those lines, I think.
Well,
so it's a question of where it comes in the batting order, not in terms of precedent, but just in terms of number.
Well,
so Schedule 2 beats Schedule 11.
Well, my lord, at the risk of discovering whether or not your lordship studied Anglo-Saxon, I think that what I would say is your lordship asked me what if everything else fails, and the answer is it's that.
Right. Yeah.
And so,
unless it's a will.
Apparently this principle doesn't apply if it's a will. All right, well, we have that. We have that point. Internal inconsistency.
My lord, I think those are the points I might make fairly, and I'm grateful to you for giving that answer, such as it is. But I think it's the answer I needed to give.
No. I mean that's fine. I asked the question to see if there was anything further. So I'll just ask Mr. Power if he wants to say anything solely confined to that point.
To the principal point.
The internal inconsistency reference and the Schedule 2 beating Schedule 11 because it comes earlier.
I don't think I need to respond to that, my lord. Obviously, I can't imagine that would be a principle that would guide the court ultimately in determining.
Well, I don't think it's any secret that the court would be endeavouring to strain every sinew not to get to that.
Precisely. I just think it would be like tossing a coin, really. It can't be a principle of any real note. Just on the pleading point, my lord, I just make the point that obviously we were pleading to the case that's made against us, i.e. the cost of replacement.
Yeah, I understand.
And since then, things have
But everything's moved on because what we're trying to do, whatever the pleading points, and up to point, whatever the judge found, we're now, it's now in that sense us looking at it afresh, because although one always pays great respect to the judge below, and in this case particular respect because of Judge Davies's reputation, when it's a point of construction, as I think I made plain when I gave permission, whatever views one might have, very often you can see that there is a real argument the other way, and therefore it's the court's duty to give permission, and in those cases it means that we are considering it for ourselves. Okay, thank you very much. Right, so that concludes the submissions. Thank you both very much for your submissions, and to those who sit either alongside or behind you. You won't be surprised to learn that we will reserve our judgments in this case. When the judgments are ready, they will be in draft form. They will be provided to you so that you can correct the spelling and the grammar and any obvious factual errors, but it's obviously not an excuse or a reason to re-argue the case. The drafts are provided on a confidential basis. My clerk will have a list of those lawyers to whom the draft is sent, and you're both aware, following the Counsel General of Wales case, that there are strict rules as to who can see it. It is effectively the lawyers on the list, plus any of your lay clients from whom you need to take specific instructions. That's the broad limitations to it. Once you've, at the same time as responding to the drafts, can you please see if you can agree an order? We hope you can. If you can't, the best thing to do is to provide a draft order with the different bits in square brackets, and to provide short, very short, written submissions as to why you say the order should say the bit in square brackets for which you are advocating. The order then can be considered by the constitution of the court, and we can reach a view on it and hand the judgment down, and we can do all that, and we'll do all that remotely. There won't be any need for attendance. All right, thank you all very much.